So as I noted in the previous small cut of the video, the previous slide, Exhibit 1.6 in your textbook does a really lovely job of outlining all the different statutory definition of employer. For example, Title VII says 15 or more workers for a specific period. ADEA says 20 more employees. Americans with Disability Act is 15 or more workers. Fair Labor Standards Act, individual and enterprise coverage is addressed in more detail in Chapter 16. But basically, what is considered to be an enterprise is different. And understand that just because we have federal definitions of what are considered to be employers, recognize that states have similar legislation, often with lower thresholds. And we'll see this highlighted across the different chapters as we get into more detail on age discrimination and disability and things like that. I know for a fact that in some states, age discrimination can go as low as 18 and as high as 70, and some of it goes higher than that or has no limit. So there are some states where age discrimination is broad and it's not just 40 and older, as it's defined in the ADEA. So of course the number of employees needed can be considered an employer is going to vary from state to state as well, since even the provisions for age discrimination may differ from state to state. There are some aspects of non-compete agreements that limit or add extra burden to the employment contract that an employee has with an employer. For example, having a non-compete agreement means that they cannot go work for a competitive employer for a specific period of time or within a specific region. They cannot solicit employees or customers from the existing company into the new company, and they cannot disclose confidential information about the employer. And there's three different types of sort of categories there. One has to do with whether or not I can work someplace else. The other one is whether or not I can have employees or customers from another place come follow me. And the other one, of course, is whether or not I'm going to sell the trade secrets of KFC chicken or Coca-Cola, right? When we don't want to disclose, we're not allowed to disclose confidential information, trade secrets of an employer, and bringing that with us to a new employer. The trend is moving upwards in terms of non-compete agreements. It was about 18% of employers had non-compete agreements, and in 2014 and then 2019, when this was initially researched, we saw 27% of the workforce had non-compete agreements, and I'm sure that it's even more so now in 2021. The goal of the non-compete agreement is to really make it a disincentive for someone to go and work for a different company, to switch jobs in a competing field. Of course, there are some states that limit where they can be used. California, of course, comes to mind. Illinois also has a law against non-compete clauses for low-wage workers. So there was a period of time where Jimmy John's had a non-compete agreement for their entry-level workers who made like $9 an hour. And again, what trade secrets do Jimmy John's, people know other than, the order in which you put meat and cheese on a sandwich, right? I mean, there's reasonable non-compete clauses, and then there are unreasonable restrictions, and we'll talk about those restrictions in a few moments. But it is important, though, when you have an employee relationship that might cross over state lines, that you have to engage in what we call forum selection clauses. So we need to be clear under which state the non-compete agreement is in existence, and obviously the employer is going to choose the state that benefits them the most, but you should be aware of what if you're working for a company that crosses state lines and is in multiple locations, that you're going to make sure that you're clear about which state law is going to be, have precedence over the non-compete agreement in that situation. So some of those restrictions, constitutes a valid non-compete agreement? Number one, it protects a legitimate business interest and it is ancillary to a legitimate business relationship. And what that basically means is it has to be very central to the organization's business interest. It is not no more broad than necessary to protect those legitimate business interests. And so again, going back to the Jimmy John's thing, Jimmy John's wants to protect their sandwiches and the way that they make their sandwiches, but there are many things that go into the quality of their sandwiches, and it's not anything necessarily that the employees know and would necessarily know. So requiring them to have a non-compete agreement because someone's going to make a sandwich similar to Jimmy John's is challenging, particularly if it's unreasonable for somebody who makes $9 an hour to have to compete, to have to engage in a non-compete agreement. It has to be reasonable in scope. It has to be reasonable in territory. It has to be reasonable in duration. So even if it's a higher level position, for example, I know of somebody who used to work for Anheuser-Busch, and she was engaged in doing marketing and advertising for Anheuser-Busch, and she came up with the ad campaign of Spuds MacKenzie. And when she left AB InBev, it was Anheuser-Busch at the time, and she went to work for her own company, she couldn't do it for 2 years. Now, was that reasonable? For a high-end executive who made 6 figures, yes, it was reasonable. There was stuff that she could do in the interim to make money, to do different things, and it wasn't going to harm her in any way. But if it were a Jimmy John's employee that they couldn't use it, they couldn't work in another fast food restaurant like Subway or McDonald's for 2 years, that would be undue hardship to them. And so we want to make sure that we have a reasonable scope, territory, and domain that's commensurate with the business interest and the secrets that you're protecting, right? We want to make sure that when we're doing something, it's also not contrary to public interest, right? We want to make sure that, public interest wants people employed and it wants people working. And so we certainly don't want to be in a situation where we're doing something that's against the public interest. Trade secrets are really important because trade secrets have a tremendous amount of value to a company because that secret is the thing that is their competitive advantage, and companies have every right to protect those issues. You all know the stories around Coca-Cola and the recipe for Coca-Cola. Not any one person has that recipe. It's broken down and different people have different aspects of it. It's kept in a secret locked location, and that information cannot be shared. And you can't even serve somebody a Pepsi and call it a Coke without them coming after you in terms of trade violations and things like that. Coca-Cola tightly holds the brand image and content of Coca-Cola, and so it's incredibly important for companies to protect those competitive advantages for them. So we want to make sure that we are not sharing confidential information or customer preferences or marketing strategies with another company. So we will have our employees sign a contract saying that they will not disclose any of this information if they leave and go to a different company. So, so those trade secrets have to be clear. So if you know something that's really important to the competitive advantage of that company, you're going to be restricted in being able to use that information to go elsewhere. Obviously, there are things like the doctrine of inevitable disclosure, where employers are protected against disclosure of trade secrets even if there's a non-compete in balance. So if they think that there's a threat out there, if there's any possibility, it's still considered, a violation, and we need to be particularly careful that we are not sharing what is considered to be an important trade secret of a company, even if there isn't a non-compete involved. If there's an assumption that it is a protected information, and we need to be careful about that. And the two-prong the two-prong rule, it basically is or three-prong rather, I'm sorry, that the courts look to, number one, whether the employer's knowledge is exceptional exceptionally specialized and technical, whether that would give the business, former or new, a significant advantage in the market, and whether the employee could perform his or her work without it, right? So those are the three rules around this idea of inevitable disclosure. So here's our final management tips. We want to evaluate and classify workers carefully and monitor ongoing work. If we don't classify them properly, it can be very costly. We want to make sure that we are not hiring independent contractors as a safe harbor from liability because it's inappropriate, right? Staffing firm contracts must be carefully negotiated and clearly spells out responsibilities and covered risks. So we want to make sure that we are reading the staffing contract that we use with a staffing firm to know who's responsible for what, if we're using a temp worker or a contingent worker. We want to understand the state's enforceability of non-compete agreements and draft for reasonableness. And we want to make sure we're clear which state is responsible at a particular point in the negotiation, which state has precedence. And then we want to be careful about our non-disclosure agreements so that we know that they're protecting intellectual property and trade secrets, but they're not creating undue hardship for the employee so that they cannot get out and go and do the things that they would like to do.